Good evening, ladies and gentlemen of the audience, staff, members of the planning board. Welcome to the Wednesday, January 26, 2022 meeting of the Cohasset Planning Board. It is 6:31 p.m. and we are operating in Zoom virtual meeting. I'm going to call to order the planning board and then begin with the first item on the agenda. But before I do that, I'd like to ask Ms. Director Lind to please explain to the public how they can contribute to the discussion.
Thank you very much. Yes, so thank you everyone in the audience here in the attendee section. We ask that you use the question and answer function to communicate with the board. There, you can find it on the bottom of your screen. We won't be utilizing the chat function. You'll find that it'll be disabled. We do ask that you input your name and address. You can either leave written comments into the chat or you can just indicate that you'd like to address the board for a certain topic. And for each public hearing, there will be a designated public comment period. So again, just name and address in the area there in the question and answer. And then if we do promote you, we ask that you just repeat it for the record. So thank you very much. I'll turn it back to the chair.
Thank you, Ms. Lind. I want to recognize Carolyn Murray, our legal counsel. Also, we have John Hallen, who is the building inspector, and Angela Giso, who is taking minutes for this meeting. So with that, I
just interrupted. Paul Grady is amongst the attendees. So.
Oh, great. Thank you very much. Mr. Grady?
There he is.
Can I hear your presence?
As soon as I unmute, you can.
Thank you, sir. So I will now turn the discussion over to Mr. Hallen, who is the building inspector, and he will work with us and the applicant talking through the final revised plan set of 124 and 87 Elm Street. Thank you, Mr. Hallen, for being here.
Thank you, Madam Chair and other members. Yes, I think it was 2 weeks ago now, the applicant had come to see Lauren and I regarding the minor changes. So we did review those changes with the applicant, made a list of the plans. What's taken place that pushed some of these changes was the final structural drawings for the building as well. So maybe I'll just go through some of the changes they put through. Again, most of them you have to look pretty carefully to pick up on the new plan and the existing plan. So one of them was the final floor plan and unit layout based on the structural system. Resulted in some minor changes in the elevation of some of the windows. It didn't reduce the size of the windows. It just changed some of the, again, location of the windows. A couple of doors leading out to balconies got moved to either one direction or the other, which we felt was pretty minor. So you really, it was really difficult to pick that up on the visual between before and after. On building at 124 South, they had a slight reduction in the footprint due to the change in structural. They pulled it back a little bit on the massing on the street. It was, as I say, again, a very minor change. It didn't result in more than Ted, jump in if there's anything I missed, but didn't result in more than a reduction of a couple square feet in a few of the units. Again, most of that was due to the structural change. On 87 building, they had the front elevation gable, went from a gable to a gambrel. Again, the massing was very similar, and it was a minor change. It didn't affect the square footage on that part, so that stayed consistent. They didn't increase the square foot or deduct it. They did add one parking space in the parking plan. They were able to get one more in. There was a deck in the amenities deck over at building 87. the building into the private terrace adjacent to the units. So it went from, I guess, an amenities deck to a private deck between two of the units. So again, the size stayed the same. There was no change in that. It was just who had access to it. And let's see, what was the last change? If I missed any here, I think that some of the other minor changes they did include in their plans, all the HVAC utilities and stuff, chimneys that finalized, so that there was some minor changes in the interior of some of the buildings. Again, but that was to move things around for the chimneys that came through in those points. But I didn't think that was relevant to the exterior, so we didn't really include it.
Thank you, Mr. Hallen. Is that all that you'd like to report?
Yeah, that's it. The other, they did issue most of the other stuff that they had given us was the compliance regulations, so that they were updated lighting plan, all the submittal of data that had been requested from the planning board. So that was not a change, but just an update that information is being brought forward and received as part of the building permit application.
Well, thank you. Mr. Lubitz, would you like to make any comments?
No, I think John captured it, but I just want to reiterate that the entire project still remains compliant with the zoning overlay, and actually it continues to exceed that compliance. So no change to building height or increased FAR like that. If anything, there's some slight reductions here and there as we work through the structural systems.
Would you mind giving us an update as to where we are in the progress of the project?
Yes, of course. So hopefully some of you all have been down to the harbor recently and seen the demolition, which is underway. It's taken longer than we all would have expected, but they're making good progress. We did have to empty out 55 fully furnished hotel rooms, so that actually took longer than we expected, but that is underway. And I know that our demo contractor is in the process of submitting a demo permit for the building across the street, 87 Elm. So that application will be forthcoming. We are working on construction financing right now and expect to close imminently on that. And we received a written determination from DEP 2 days ago on the Chapter 91 license process. Which was a very favorable review. The determination indicated that we were in fact eligible and we had satisfied the conditions for Chapter 91. So things are trending in the right direction on that. And we hope to be in the ground sometime in March or April doing foundations and going vertical, which could put a project completion sometime around 2023.
All right. Well, that's really great to hear. Let me ask the planning board members if any one of you would like to make a comment. I see Mr. Callahan.
I just wanted to ask Ted, Lauren, and Carolyn where we are on the further agreement between the town and the developer about the use of the public space. Are we waiting for the Chapter 91 process to finish before we dig into that, or where are we?
Yeah, I can provide an update just on that. Lauren, I had a similar question to Tom, so I did a little more diligence with DEP and our attorney on that. So the process is they will issue a license condition on that public access agreement. So, which again is that management plan that we discussed a while back. So once the license is issued, that's when the management plan will be negotiated back and forth with the town being a party to that agreement as well.
Okay, great. Thank you.
Ms. Lind.
Thank you. I'd just like to update that I did receive notice yesterday from the town manager's office that the attorney representing the applicant and the select board have been communicating about the easements language too. So there will be an update forthcoming on that.
And
All right. Thank you. That was Mr. Hallen.
yeah, I just wanted to follow up on that. Also the easement language that they're putting together for, with the town will agree with the plan. So the wordage and the plan in place will both coincide so that we don't have any discrepancies between those two. So I think that's the process they're taking care of right now so that everything adds up.
Thank you. Mr. Brewer, would you like to comment?
Yeah, I think the plans, the elevations, the views, the completeness of the application is appreciated and it looks good. I mean, it's a little bit different a design, but I would say that what was put together builds on what was approved. I particularly had made comments about the glass balcony areas where the fishermen at 4 a.m. could look up into the living room and that might not be great. And I think those kinds of issues have been addressed, at least in part, to provide some additional privacy for those unit owners. I did have a question of, and I will say that the HVAC units they appear to be screened and hidden from view. John, I don't know if you had a chance to check on the acoustical data for the HVAC units on the rooftop.
I did. I know that was submitted. I did not kind of read into it completely. I think whatever the data is, we'll have to just look into that. I didn't think it was a change at this point, so I thought it would just be more as a review.
Right. We want to make sure that those units are quiet relative to anything else. So if you could take a look at the spec sheets on those, that would be great. I also noted that there's louver windows on the ground floor, especially on the street side, for the parking. As if I put on my architect's hat, I'll assume that that's so that space can be classified as open parking. I think it requires like a 50% or more openness.
So, yeah, so there are two types of louvers. I don't know, on the 87 Elm, those are actually floodgates into the garage.
Yep.
124 and north and south building. Those are some mechanical louvers. We do expect this to actually be a closed garage, so it's not striving to be open air right now.
Okay, so there's like a wooden type of louver on the outside that conceals a mechanical or powered damper type of louver on the inside.
Yeah, that's my understanding.
And the picture of those louvers, the wooden part that we see, it looks really good. I guess my question would be, is it made out of teak or Iroko or something that's gonna hold up over the decades? Would it then be a maintenance issue? Because it's sort of a new element that we haven't seen. I mean, the detail shows louver or trellis. I think either of them can do the job of concealing a mechanical grill on the inside. And I'm okay with it being flexible, provided that it does its job of sort of jazzing up that necessary mechanical element. Was that a question?
Well, I'll try to answer it, but I don't have the details on the materials right now, but we will submit those as part of the building permit. But again, the idea is for screening and, architectural aesthetics.
So the goal is to conceal those mechanical elements to the extent possible, and that it'll look really great and hold up.
Yes.
Again, exposed wood sometimes finishes hold up the way they're guaranteed or warranted in the brochure, and sometimes they don't. I don't see any cut sheets on the garage doors. Are those open garage doors? Are they metal? Are they painted metal?
No, the intent on the main garage doors are to be a high quality sort of normal residential / commercial garage door. The two garage doors connecting the north and south building, we're exploring different types of garage door systems, which we'll submit as well. But we're trying to do the high-speed, quiet doors that you see at car dealerships. So that's what we're contemplating and considering, but they'll be very aesthetically pleasing, provide, make sure that there's not ability to get in the building but also won't slow down the circulation from building to building.
That sounds like a good plan. So a resident would put their card in, the door opens and they get in there and it closes right behind them. It's got eyes and all kinds of safety gear and stuff like that.
Yes.
Okay. I think that covers the points. Again, I think that the design evolution is excellent. And I think it's in keeping with what we saw and approved before. And in some cases, I think it's an improvement, but it is different. There's definitely like some aspects of the fenestration and the massing that's a little bit different. But all said, I think it's in keeping with what we approved.
All right, thank you, Mr. Brewer. Mr. Grady?
Oh, it's just a couple. I mean, I may be jumping the gun here, but I got a couple questions. When do we hear about the affordable housing component, and when do we start discussing the performance bond that we've brought up and the amount?
Mr. Lubitz?
So Lauren, you want to handle it for me?
Sure, I can speak quickly to some of those. So some of the conditions that we've had in the decision are triggered by a certain action. So the performance bond will be contingent upon the issuance of the first building permit, is the way that it's stated in the language. And for the update on the affordable housing piece, I can confirm that we've been in communication with the applicant to get the material submitted to the Department of Housing and Community Development. So it's ongoing. I don't have an update as to exactly when we anticipate those units becoming available and eligible for deed certification, but it is in progress.
And the amount of the performance bond, will the planning board determine that?
I believe the way it was framed in the decision was that it would be in communication with the building inspector and the Department of Public Works, but I will have to double check on that.
Yeah.
Okay, thanks.
All right, thank you. And welcome, Mr. Potter. We are in the process of discussing the final revised plan set for 124 and 87 Elm Street. I know you just popped in, but if you have any comments, would you like to present them?
No comments right now.
All right, thank you very much. So you covered all of the issues that I was going to ask questions about, and I really appreciate that. Lauren, how do we go from here?
I believe that's all that we have to discuss for tonight. More updates to come as this continues to progress and hits certain milestones as outlined in your decision. But at this point, I think the board is in consensus that the updates that John Hallen has reviewed with you are minor in nature, and there's no further action that needs to occur.
All right.
We don't have to vote to accept the final revised site plan at this time. We're just getting updated on what the minor modifications are that has been reviewed, and it's just a communications.
Thank you. Ms. Murray, do you have anything you'd like to say?
Nothing, Madam Chair. Thank you.
All right, thank you. Well, Mr. Lubitz, thank you very much on behalf of the town, and we wish you the best of luck, and that you get rid of 55 rooms worth of furniture as easily as you possibly can. I'm sure that was a real shock. You could have made something stand as tall as the building itself. And we look forward to the future reports. So thank you.
Thank you. It's good to see all of you.
The same. All right, we're still doing very well on time, right on the money. So we now are going to be opening a public hearing. And Mr. Grady, would you please read the public hearing document?
Certainly. Could you put it up for me?
I certainly can. One moment,
Thanks so
please.
much, Lauren.
Have to make it a little larger here.
Ready to go?
Yes, can you see the screen?
All right, thanks. Notice of public hearing, Cohasset Planning Board. Pursuant to Section 81W of Mass General Law, Chapter 41, the Planning Board will hold a virtual public hearing on the Zoom platform, webinar ID 849-4127-5837, password 965249, on Wednesday, January 26th, 2022 at 6:30 p.m. to consider modifying, amending, or rescinding a 23-lot residential subdivision approval decision for property located at 602 Jerusalem Road, otherwise known as Jerusalem Road Estates Subdivision, filed with the town clerk on October 8th, 1998. A copy of the Jerusalem Road subdivision decision and plan is on file at Town Hall at the office of the town clerk during normal business hours and can also be found on the town's website, www.cohassetma.org, under the tab Acting PB Applications of the Planning Board webpage. Pardon me. Any person interested or wishing to be heard on the proposed amendments should attend the virtual meeting at the time designated. Signed, Amy Glassmeyer, Chair, Planning Board.
Thank you, Mr. Grady, for reading that. Let me begin by describing how this conversation will proceed. I'm first going to turn to our legal advisor to give us a background on where we stand. I will then turn it to Director Lauren Lynn to fill us in on the sort of history of how the laws have changed from 1998 until now as it relates to regulations of subdivisions. We will then proceed to speak with the applicant. We will then move on and talk to the planning board members, and then we will have further conversations. So with that, Ms. Murray, please begin.
Thank you, Madam Chair. As the board recalls, back in December, you had this 23-year-old subdivision plan presented to you requesting certification of the board at that time. And for various reasons, primarily being the fact that the board did not have a copy of a file to which to compare the plan that was presented to it, the board voted to deny certification of that plan so that it could not go forward with being recorded at the registry. But furthermore, the board also voted to hold this hearing to consider either modifying or rescinding the subdivision. Now, since our hearing in December, we've obviously received our copy of the lawsuit from the developers that's pending with the land court. But still, this hearing goes forward tonight. We've also had a chance to dig a little bit deeper into the status of some of the town's files on this matter. We've confirmed that the planning board file was destroyed with the permission of the Secretary of State's office in 2013. But luckily, the town clerk's office does have minutes, which we've been able to go through some of them. I don't know that it's a fully exhaustive list just yet. And the town clerk was able to locate one file. And I can tell you the file consisted of the original 1996 subdivision plan. It consisted of the Form 4, which was just the application. It consisted of the 100-year floodplain and stormwater report that had been prepared by Carr Laboratories. And it also had an environmental impact report. That is the sum total of it, of the town clerk's file. So looking at this kind of leaves the board tonight where your considerations are, one, to modify the plan. And we can talk about what modification could look like, but as the name implies, it would be a modification with an eye towards the plan keeping its status as a quote unquote improved plan. Or the other option is to rescind it altogether. And if the board is to rescind it, we do need to state reasons in the record as to why we would rescind it. Now, a moment ago, I said whether or not this plan retains its status as an approved plan, because I think that is somewhat of a debatable status to assign to this plan. The original filing goes back to 1996. Minutes reflect that in 1997, there was a request to withdraw a plan without prejudice. At some point, a 1998 plan comes back for consideration. We don't have all of the records to suggest that all of the prerequisites of the subdivision control law were complied with. Namely, anytime a subdivision plan is filed, it's supposed to be submitted to the Board of Health for a report or recommendation. We've only been able to locate one set of minutes germane to this time frame with respect to a Board of Health filing, and that goes back to 1998. So we don't have anything from 1996 or when the plan was under consideration from 96 to 97. My understanding is the Board of Health did have something relative to 2006, which is a time when the developer submitted a 6-lot subdivision for this same property. But here we are in 2022, and in 2021, the applicant was asking this board to certify the 23-lot subdivision. So I can't really give you much history behind this 6-lot subdivision. I can tell you that that on October 7th, 1998, the planning board at the time did approve a 23-lot subdivision. There were waivers that were stated, and there were some conditions attached to that approval. When you look at the plan that was presented to the board in November, December of last year for certification, that plan, number one, had a number of revision dates on it that ran through, I believe, February of 1999. We have not been able to match up minutes of the various board meetings to confirm many of those dates of revision. The face of that cover page of that set of plans that was presented to you notes 6 waivers on the face of it. Comparing that to the October 1998 planning board decision, 3 of the waivers noted on the cover page of that subdivision are not even mentioned in the planning board's decision. So I don't know if there was a subsequent request for further waivers. We simply don't have that record. Another prerequisite, obviously, is a request. The applicant is supposed to present some form of surety to ensure that the subdivision roadway would actually be constructed per the plan. The statute requires that the planning board is not supposed to endorse the plan until such time as that surety has been provided. We have checked with the treasurer's office. There's no record of a surety having been presented there. Some of the minutes refer to a covenant, so it's possible that the form of surety intended was to be a covenant. The covenant was supposed to have been reviewed and approved by town council before any documents were signed, again, per the planning board minutes. But we don't have any indication that the covenant was presented to town council, that it was approved, or that there was any kind of report presented to the planning board to ultimately go ahead and sign the plan. What we also have discovered is that an abutter to the property at 604 Jerusalem Road, I believe the name is Kenneth and Deborah Brewer, no relation to the planning board member, as he's disclosed, but they filed an appeal of the subdivision approval. That appeal, according to the Norfolk Superior Court docket, was not resolved, or I should say the judgment of dismissal did not issue until March of 2002. If we go and look at the face of the planning board if we look at the face of the subdivision plan, it bears the signature of a single person, that being the chair, and it appears to have been dated. Again, this is difficult to read with the digital version, but it looks to me like the date appears to be April of 1999. And I submit to you that, first of all, April of 1999, the chairman could not have signed the plan because it was still under appeal at that time. More importantly, the subdivision control law requires that a plan be endorsed by a majority of the planning board, unless there is a vote of the planning board authorizing the chair or a clerk or some other designee to sign the subdivision plan. We've looked at that online. It's supposed to be, that vote is supposed to be on record at the Registry of Deeds. We have not been able to locate it. I checked with Lauren Lind. She doesn't have any record of such a vote having been taken. So there's a question as to whether or not that signature by the chairman, whether that was sufficient or even appropriate, given the timing of it. So all of this raises more questions rather than answers at this point with respect to the plan. So as I see it this evening, the board can either modify the plan, and that would be perhaps looking at whatever prerequisites such as a surety you would want to impose upon a modified plan. And it would also include, I would imagine, wanting to look at a review of, if this plan were presented to the board today, what additional types of safeguards would the board put in place? Or let's also nail down these waivers, because as I said, I don't have any record of the planning board having approved all of the waivers as presented on the face of the plan. If the other option, of course, is rescission. And as I said, the case law requires that rescission be for good cause. I've laid out some of the deficiencies that I certainly see, at least with the statute as well as process, that certainly seem to indicate that there are some deficiencies with the plan that has been presented to the board. And I know that Lauren Lind has gone through and has prepared at least an initial review of some changes with respect to zoning or the subdivision regulations that, you know, the board may consider to be substantive when we view this subdivision today. One thing I do want to point out to folks is that, you know, when the subdivision was filed and then subsequently approved, by state law, they enjoy an 8-year zoning freeze from the date of the original filing forward. But when there is an appeal that is presented, that zoning freeze, excuse me, is also extended based on the amount of time it takes to resolve that appeal. The Brewers appeal was resolved as of March of 2002. Even if we added an 8-year zoning freeze to that, that brings us to 2010. And as I mentioned, you know, we all know that this was presented to the board 12 years later. So with that, I guess I would hand it over to Lauren, unless the board has any questions from me at this juncture.
Let me just say that if the board will please bear with me, I'd like to allow Ms. Lynn to speak, as well as the applicant, and then the planning board will speak, because that'll be a very efficient way. So Ms. Lynn, please proceed.
Thank you all. First, I'm going to go over some just a quick zoning analysis of the site and give you some history of changes that have occurred since this plan was approved. Just so for background information, this site is approximately 4 to 5 acres of undeveloped land split between Residence B and Residence C districts. We do know from our available maps on our town GIS database that there's presence of wetlands on site, potential locations of vernal pools, and our aerial imagery depicts that there's somewhat heavy vegetation on the site. This, as you already heard the application history, I won't go over that in more detail, but some bylaw changes that have occurred since 1998 that would impact current day development for a property of, any property of this nature include the Stormwater Management Bylaw, which was established via town meeting in 2008. It establishes the Conservation Commission jurisdiction for regulated activities pursuant to the Federal Clean Water Act. We also have the introduction to our zoning bylaws, inclusionary zoning that applies for any residential development containing 5 or more units within any district. And our scenic roads bylaw, that one of them is Jerusalem Road. So that may also impact this lot. And then you also have land alteration, both the two pieces, one that was passed at annual town meeting regarding tree clearance, as well as the most recent portion for ledge, exposed face ledge protection. And then last, I just want to note the rules and regulations. So the planning board rules and regulations governing the subdivision of land originally were effective in 1954, subsequently revised in 1989, and then again in November of 2016. And I did do an analysis to compare the 1989 and 2016 version to go through and see what might be, some more substantive changes. While there are a lot of administrative and sort of language modifications, there are also several that I flagged for council and your purposes to take a look at. And I'll just quickly run through these. It's a bulleted list. There's a requirement, of course, for filing at the Registry of Deeds. There is a section that adds consideration for consultants and fees for peer review. A certification of compliance is required for an application that would certify compliance with our rules and regulations, zoning bylaws, subdivision control law. It adds new requirements for utilities, grading, drainage, new figures that go along with those for our change in minimum standards for dimensions between infrastructures, subgrade, as well as mass pipe construction standards. It does include a new reference to vernal pools, which we previously didn't see in the version from the 80s. It also adds specific language that there's an ability to condition approval such that if construction and installation of ways and utilities within a 2-year period was incomplete, it would automatically rescind the approval without further action of the board. We see introduction of new performance guarantee criteria, sort of a first introduction of consideration of sustainable development principles and reference to our open space and recreation plan, as well as consideration for emergency turning vehicle radius and roadway foundation specs, as well as last but not least requirement for a written waiver request, which, as we know in our case history looking at this site, would have been quite helpful in understanding the history of what had happened between the iterations of plans. So with that, I'll conclude my summary of modifications to the zoning bylaws and the rules and regulations that you might want to consider as you think about maybe modifying or rescinding this plan. So thank you.
Thank you. Mr. Grady, if you would hold your comments so that we can hear from the applicant, that would be really helpful. And I want the public to know that after the applicant speaks, Ms. Lynn will explain how the public can participate in the conversation. So with that, Mr. Buckley, would you like to make a comment? You're muted, sir. Thank you.
Thank you. Thank you, Madam Chair, members of the board. I appreciate the summary from Town Council, but that does not negate the fact that I believe that our position is that we have an endorsed subdivision, whether the person was authorized or not. The town records apparently don't seem to allow that to be determined at this juncture, but the plan, had we recorded it initially, it would have been recorded and it would have, it bore the signature of the chairman of the planning board at the time. So our position is that it was duly authorized and executed. With respect to the security, under the Subdivision Control Act, security for the performance of the obligations for the layout of the roads and the utilities is at the applicant's choice. So you can either do cash, a surety, or a covenant. The endorsed plan does indicate that a covenant is to be executed. And while our records don't seem to have it, I'm not sure, obviously I wasn't involved at the time, whether that was provided. But if you want a covenant to secure the performance of the obligations under the subdivision plan, we'd be more than happy to execute the town standard covenant with respect to subdivision compliance. And I don't think that's an unreasonable request. The council is correct with respect to the appeal, tolls any zoning freeze during the pendency of that appeal. But more importantly, one of the conditions in the endorsed decision of the planning board at the time that was filed the next day with the town clerk, the first condition of the subdivision approval is to tie into the town sewer. And there was no availability, or that was an impossibility of condition at the time. The Subdivision Control Act also extends a zoning freeze that during that period of time when one cannot tie into municipal services such as sewer. So to the extent that the sewer was not available, that condition required us to tie into sewer. Until that sewer is available for us to tie in, the freeze that was effectuated by the subdivision would continue. And I think that's established law. There are, granted, there's a tremendous amount of time that lapsed. We're as puzzled as perhaps the board is as to what occurred. But I think that in order to rescind a subdivision or revoke a subdivision, there has to be a basis that it can be that you just don't like it or times have changed. At the time of approval and the record as it stands now is being assumed that these things didn't occur. It's just as likely they did occur. So we're at a quandary. So our position is that the subdivision was duly executed, is valid, and any freeze that was effectuated by it is likely still in effect because of the moratorium or the prohibition on satisfying the conditions of that approval, which first and foremost is tying into the town sewer. So with that, I'll stop. Thank you.
All right. Thank you, Mr. Buckley. I'd like to ask Lauren Lynn now to please give the public the instructions of how they can communicate. They will be speaking after the planning board members.
Thank you. So we would ask that you insert your name and address into the question and answer function at the bottom of the screen. You can either leave written comments there, or you can indicate that you'd like to address the board, and we will promote you to use your camera and speaker at that time. We ask that we keep comments to a 3-minute maximum per person, and please try not to repeat items that have already been stated, and keep topics to the discussion at hand. Thank you.
All right. I will now call on the planning board members alphabetically, starting with Mr. Clark Brewer.
Grady had his hand up first, so if you don't
Thank you,
mind.
Clark. I
I'd like
appreciate
to
That's
start.
fine.
Thanks, Clark. I do appreciate that. Just looking at this and hearing a couple of these, and listening to Lauren, listening to Carolyn, and listening to Mr. Buckley, there are just far too many inconsistencies in this application. It's over 24 years old. There's information that can't be found, information that's vague. You have an approval signed by a single member who happened to be the chair again, but bylaws have changed. And, my instinct here is I want to file a motion to rescind and allow the applicant to reapply with, to use vernacular, ducks in a row, but using what we have for existing bylaws. Again, too many things have changed. There's too many inconsistencies, missing information that can't be found, can't be supplied. So at this point, I'm filing a motion to rescind.
Thank you, Mr. Grady. With that, I'm going to proceed to still call on the planning board members and leave that active. Mr. Brewer?
So you're going to leave that motion? It hasn't been seconded. There's a motion. You made a motion.
We can come back to it.
But what I think it makes sense to get everybody's comments. Paul, would you mind?
Just leave it hang out there. We can
Okay.
come back to it. So make your
Right,
comments.
Mr. Brewer, proceed.
Right. So this is a big project. The 40-something acres, 23 lots with wetlands, and it has a huge impact on this part of Cohasset. I really think that that the burden is on the applicant to make sure that if a chairman was duly authorized to endorse the subdivision, that applicant has that documentation, and I think the burden is on them, not on the town, even though the town has looked for that documentation. I think that it's the burden is on the developer or applicant's team to follow up in a timely manner. But based on what council has told us, I don't think we have an approved subdivision to rescind. I mean, I guess rescission is maybe that's the right way to go about it. But if it was under appeal in 2002 and it was signed in 99, then we don't have an approved subdivision, period. So how do we rescind that? Now, on the applicant's side, there's a tremendous amount of documentation that they've put together. They've probably learned a lot about the site through Concom, perhaps Board of Health, and I can't confirm that, and through their process with the planning board back in the 90s. And so I think that there's really no option for the applicant other than to refile or create a new filing for this area. And I think that a lot of the best practices in stormwater management and just all the things that mean being a good neighbor would make a big difference. The equity picture compared to now from 99, I think allows the developer the ability to understand that those extra precautions to make an excellent neighborhood and to be an excellent neighbor for the people that live around this particular lot, that the opportunity is there. I just think I don't see that we have something to rescind. But I mean, I suppose we could have a motion that if this is a subdivision that was approved 23 years ago, we would rescind it. Because from what I've heard, I don't think we have an approved subdivision here.
All right, Mr. Brewer, we'll also come back to you. Mr. Callahan?
That wasn't a motion. I was just making a suggestion.
Thank you.
Well, I think for our board and every planning board in the state, as a matter of principle, we can't condone approving a plan 24 years after the fact. The reason we're here is because the applicant failed to record a plan within 6 months under the statute. The applicant failed to provide surety. We're not here in the business to relieve the applicant of their mistakes. And I think it would be horrible precedent if we did. And, you know, this is, I wish I could remember this. I'm the only one here who was on a board at the time. I was on Concom when this project started in '96. I don't think I was there when Concom made its decision, but my understanding is Concom essentially denied this project, and there was a court action, and that ended in 2005, I believe. The sewer issue, there may have been a moratorium, but it's my understanding that the Sewer Commission outright denied a connection at the time. There was litigation over that, and that ended in 2006. Then there is the issue that the applicant brought forward in the mid-2000s a second plan that I understand the planning board denied, but was for only 8 lots. So just the passage of 24 years is enough for me to say that this has been abandoned. But it was abandoned back in the 2000s when they came back with another plan because they were facing denials from the Sewer Commission and the Concom because of all the development that was involved with 23 lots that just wasn't feasible. And again, I'm going to end up seconding Paul's motion when it's appropriate to do so, and I'm prepared to offer some of the explanations for the decision. But I just don't see how, just on principle of 24 years, that any planning board can allow this to happen, especially with all the changes that have happened in the law, case law, statutory law, bylaws. So I can't see myself supporting anything other than rescission here tonight.
Thank you, Mr. Callahan. Mr. Potter?
I'm in agreement with the board in the comments made today by everybody else. I think the amount of years that has gone by is just a significant amount of years. It's not recent past. I have no knowledge of any thing that was done that would grandfather this decision in, or would require us to acknowledge it. So I would be of the position that if the board doesn't actively rescind it, then the applicant by non-action abandoned the rights to move forward with the prior decision.
All
That's
right,
all.
thank you, Mr. Potter. I appreciate that. I agree with the comments that have been made by my colleagues on the planning board. So I'm not going to add any further information other than to say that the project never went before the Public Health Board. So that was a stop that was missed. But what I'd like to do now is to turn to the public and allow them to provide some insights. So Lauren, can you please manage that? Thank
Yes,
you.
I will. Thank you. So I will read the comments that have been written in to date. We have first Katie and Dave Dugan of 100 Black Rock Road, just here to listen to this. Patrick and Nicole Muller, a Windy Hill residents. They write, "Hi, this is Patrick and Nicole Muller, residents of 59 Windy Hill Road and concerned about the Jerusalem Road subdivision. How much of the natural forestation would remain with such a large development? Would any of the land remain undeveloped? Very concerned about the wildlife impact. Thank you." Lindy Fitzgerald of 39 Windy Hill Road. I respectfully second Mr. Grady's motion to rescind. We cannot allow an approval, if there ever even was an actual approval from 24 years ago, to be upheld. It's ludicrous. Kelly Dunn of 53 Windy Hill here. No question at this time. Wanted to note for the record, Chad Gutner and Kelly Dunn were here. We're very concerned about this potential development in our backyard. Virginia Jensen of 542 Jerusalem Road. Resurrecting something this old and outdated is not something for this area at this time. I agree the burden is on the applicant to follow up in a timely manner. In addition, the access road, Black Rock Road, is substandard, less than 12 feet in certain areas. Nothing about this proposal is reasonable. Mel Seaborn, no address. Michael and Sherry Hefner, no address. Jill and Reed Smith, 47 Black Rock Road. 28 Black Rock Road, Michael Hefner respectfully seconds motion. Mel Seaborn, 600 Jerusalem Road. We're concerned as abutters that we had no voice in this plan. And as we were not abutters at the time of the plan, very concerned about this development. Jill Smith and Jeffrey Chubb of 56 Black Rock Road. No questions this time. We are very concerned about this development. We agree that this development should be rescinded. And Nicole Berg of 45 Windy Hill Road, here to listen. I'm not seeing any other comments in the Q&A at this time, so I will turn it back to the chair.
All right, thank you.
Madam Chair, may I make one quick comment before you take your action?
Yes, Mr. Buckley.
I would just like the record to reflect the fact that while the plan may have been signed by the chairman, which I do a lot of zoning or land use, it's not unusual to designate an individual, as council indicated, to sign. Whether that has been found in the town's records, I can't comment, but there seems to be a lot of things in that file. But one thing we did find was an actual vote of the planning board to close the public hearing and to actually vote affirmatively on a 3-2 vote to approve the subdivision. And that was filed with the town clerk on the next day, October 8th, 1998. So to say that there was never a subdivision or there was not a subdivision, the actual vote of the board is on record with the official record keeper of the municipality. So there is evidence that there was an approval of the subdivision. And I would submit that the moratorium of some of the conditions prohibited the execution of the subdivision, and as a consequence leads to some vested protection. Thank you.
All right, thank you. Mr. Grady?
Just to be brief, I know when we sign approval, we all have to sign it. We take the vote and we sign. That's not an accusation, but there's a misstep someplace. So that's where I'll repeat my motion is you start fresh, come before the board, and we move from there. And that's
Thank
why
you,
I'll
Mr. Grady.
continue my motion.
Mr. Callahan?
I just want to make the point that I'm operating from the assumption that there was a subdivision approval. I mean, whether it was valid or not, it doesn't excuse, Attorney Buckley, your client's failure to do what it had to do to protect its own interests. And again, I don't think we're here to bail them out of that. And again, on the sewer point, I think there's a big difference between a moratorium and an outright denial of a connection, which is what I understand the sewer commission did, and that led to litigation, which ultimately was resolved or settled in the town's favor, or resolved in the town's favor. I'm going to right now, I'll officially second Paul's motion I'm prepared to offer some reasoning if that's necessary, whenever you'd like.
May I just step back for 1 minute, Mr. Callahan, and ask Ms. Murray if she has any additional comments she'd like to make?
Sure.
Thank you.
Thank you, Madam Chair. I don't have any additional comments to make. I just, and it sounds like Mr. Callahan might be headed in this direction. Just ask the board that the motion be supported by some findings that we could actually put into a decision.
All right, thank you. I think that was the direction that Mr. Callahan was going, I'm going to guess. So would you like to offer some comments, Mr. Callahan, regarding conditions for the seconding of the denial?
Is somebody writing this down?
If Tom could make a new motion with his conditions, that would probably be the easiest thing for taking a vote.
All right, are you taking this all down? So,
Yes, we have Angela here and I will also take it down.
okay. All right, so I'll make a motion that we rescind the subdivision decision of, what is it, October 8th, 1998? Is that the date of it? For
Yes.
602 Jerusalem Road,
I second it.
on the following conditions that I have and that anybody else on the board wishes to add to. My first condition would be that by reason of the applicant's own actions, inactions, and/or negligence in failing to record the plan, provide necessary surety and any other acts or omissions that it was supposed to take that it didn't take at the time. The second grounds would be abandonment of the project, both by reason of the subsequent subdivision filing in the mid-2000s and by the mere passage of 24 years. Another condition, another reason would be, this is lawyer talk, it's related to abandonment, but it's the equitable principle of laches, LACHES, which is basically you sit on your rights, you lose your rights. So those would be my conditions. I leave it to the fellow members to add any others that you think are appropriate, or to council to add what's appropriate.
All right, thank you. Is there any other member of the board that would like to add additional conditions?
I mean, I'll add what everything Carolyn said earlier too, but I can't sit here and repeat everything she said, but the defects that she found earlier would be an additional condition for rescission.
All right, thank you. Mr. Grady?
And I would parrot Tom by adding what Carolyn put, also what Clark put, and what Eric put. As a matter of fact, the board as a whole. And that's why I filed the motion in the first place. But Tom, I happily second it if we're going that route.
Thank you.
Mr. Brewer, do you have any comments?
No, but the motion's been made and seconded, and I vote aye.
Thank you. Mr. Callahan?
Yeah, I mean, I'll vote aye unless there's any other discussion people want to have about it, but if we're ready to vote on. All right, I'll vote aye.
So, Mr. Grady?
Aye.
Mr. Potter?
Aye.
Amy Glassmeyer, aye. Thank you.
Your time.
All right. Thank you also on behalf of the board for the public's sentiments and views of the situation. We're now going to move to an item that was originally scheduled at 7:20. We're not doing too badly on time, which is a discussion of a lot release request, lot number 6 of Heritage Lane subdivision, continued from 12/15/21. And let me ask if Lauren would like to speak to this.
Certainly, thank you. So I'm just for the record, I'm promoting Gregory Morse from Morse Engineering on behalf of the applicant. And then we also have Jim Reardon of Weston and Sampson, who's a peer review engineer for the town, both here tonight to speak to this application. So we received this application about a month and a half ago, I'll say now, in a ballpark. It was the request to release the final lot that's being held in a subdivision known as Heritage Lane. This subdivision was approved in the early 2000s, and it has since been a period of time since there'd been a couple of lots released in previous iterations as the project was moving forward. Now the project is at its final stage, and they're looking to have this lot released so that they can proceed with development of that final lot in the subdivision. We received the request from Greg Morse, and what we had asked at the time is because there had been a punch list of outstanding items from the board's former peer review, Mr. John Modulewski, from back in 2011 that had been unanswered. We asked that as the starting point, the applicant provide responses to where that letter had left off to continue this review. So they did such, and that was reviewed by Jim Reardon of Weston and Sampson. There was some conversation, and now we're here tonight to hear from both the applicant and the peer review as to where we stand, and then the board can make a decision as to where we go with the request for lot release.
Mr. Morris, would you like to speak?
Sure, thank you. For the record, Gregory Morse, registered engineer, Morse Engineering, representing the property owner and applicant Anthony Nader of Highland Estates, LLC. As Ms. Lynn just stated, this was a subdivision that was originally approved in 2005. It was a 16-lot subdivision located off of Beechwood Street. My client substantially completed construction of the road in about 2011, and since that time has built on 15 of the 16 lots there. Lot 6 is the only lot that remains in its original condition. The applicant had put up Lot 6 as surety for the subdivision project to guarantee the construction of the road and installation of the utilities. That is all complete at this point. In 2011, John Modulewski of Civil Designs, Inc. Reviewed as-built plans that were previously submitted, performed a site visit, and came up with a list of punch list items for the subdivision to be considered complete. Since 2011, my client has substantially completed all of those punch list items. We submitted a letter documenting that those items had been done. And in the areas that they haven't, we feel that what is out there is in substantial compliance and meets the intent of your subdivision rules and regs. So we've requested the release for Lot 6. Again, Lot 6 was the lot that was held as your surety. It's the only remaining lot at this point. My client takes great pride in the subdivision. He feels that it's come out very nicely. The landscape is matured. The homes are a nice addition to the neighborhood. If you've driven through there, we hope that you would agree. I turn it over to you.
All right, thank you. Mr. Reardon, would you like to provide some commentary on behalf of the town?
Yes, I'd be happy to do that. Good evening, Chair Glasmer and members of the planning board. I have a brief presentation to go through. My apologies for remaining dark screen tonight. My internet connection is a little bit spotty and has been kind of going in and out when I have video up. So we were, of course, asked to review this subdivision by the town and for bond release, and prepared a peer review memo that was dated December 14th. As was mentioned previously, there are a number of punch list items to be addressed. In general summary here, we believe that the following punch list items have been addressed: 1 to 3, 5 to 9, 11 to 16. There were several that were listed under 17. So we think 17.1, 17.2, and 17.4 have been addressed, as well as 18 to 21. So that leaves 3 items that have yet to be addressed. They include the stormwater forebay, the formed inverts for manholes under item 10, and the berm around the detention basin. I'll give a little more detail now. So to make this determination, we looked at materials that we received from the town between November and December when we conducted our review. They include the 5 listed here. This is also listed in our peer review, so I won't go over them individually. We'll point out that we will point out that detention pond 2, item 4 in the punch list, that the forebay on sheet 11 was not found in the field. This was noted on a previous review. We would recommend that the applicant should install a forebay or explain its absence. So looking at this plan, there's no.
I'm sorry,
forebay.
Jim. Jim, what's a forebay? For those of us who don't know what it is.
Sure. So generally speaking, when you have a stormwater best management practice, you have a treatment component, you have pre-treatment, and then you have whatever kind of outlet control for peak flows that are included. And that might be part of the treatment component. A forebay is a pre-treatment component. It's designed to capture most of the large sediment particles and things like floatable litter and stuff like that. In the case of a detention basin, it's usually a pooling area that might be included before the rest of the detention basin. So hopefully you can see my cursor here, Clark.
Yeah.
Typically you might, so this is the inlet pipe,
Yep.
and that's the outlet, which you can tell based on the invert elevations. And this is the overflow. So the overflow is for peak flow control. The outlet is generally, this is for, I should say, this is for peak flow control in an emergency, say when you're getting over 100-year storm. The remainder of flows are controlled through this outlet box and through this pipe. And then at the inlet here, you'll notice that there is probably a riprap pad that's designed to dissipate energy a bit. And then typically you might find like sort of a berm or a wall along here, essentially, wall for lack of a better term, that holds back some of the flow initially so that, as I was mentioning, larger floatables and sediment particles get trapped. Sorry, my cursor went away. Get trapped in this area and you can clean them out and they don't clog up the rest of the treatment unit. So you might see this as being an excavated area here with, cursor went away again, an excavated area in here with sort of a short berm with maybe a weir wall or something of that nature to control flows. That's the sort of thing that's really up to the engineer to include. Another way to deal with pre-treatment might be to do something like install an energy dissipator or hydrodynamic separator in this area. More commonly, those go by the name like a vortex unit or something like that. Does that give a pretty good explanation for you?
Thank you.
You're very welcome. As mentioned on the slide, forebays are required for pre-treatment. They're required by the state, and the state standard is what you folks use for stormwater BMPs generally. So again, that's missing here. Another item was at the manhole having formed inlets. This isn't one at this particular site. This is an example of one, and you can see that there is a formed piece of, in this case, looks like iron that curves up over the concrete curbing, like Cape Cod sort of curbing in this area. And that the way that's formed, the way it is shaped to fit directly with the curb, that's referred to as a formed inlet. And so these are not technically, it's not really a performance issue, for a site, but they do look pretty. So it's really primarily for aesthetics and I probably shouldn't use this term, but curb appeal. So in this case, it was stipulated as a requirement in the approval, and it was one of the punch list items, and these haven't been installed. And then last, this is back to the stormwater detention system. So there's a berm there that is low in some places. It was supposed to be installed so that it would contain flow. We did notice that there is no, because we did a site visit, that there is no visible erosion problem or anything of that nature. There's no evidence of overtopping of the berm. So it appears to be functioning okay, but there were no stormwater calculations that were provided to review the claim of proper functioning. And generally, we would want to see those to show that the flows that are anticipated during various storms, that they are able to be handled by the system that's put in place. So those are the three items on the punch list that we found haven't been included yet. Otherwise, things looked okay to us.
All right, thank you, Mr. Reardon. Would any of the members of the planning, let me ask, Mr. Morris, would you like to respond?
Yes, thank you very much. Those three items, if we start with the forebay, specifically we're talking about when you drive up the subdivision, it's the detention basin that's on lot 1, which is the second lot on the left-hand side. This project started by a previous engineer, Neil J. Murphy Associates, and back when the road was constructed, 2010, 2011, an as-built was submitted that indicated that a forebay had been constructed within that detention basin area. Since then, that property, lot 1, has conveyed, and the homeowner has gone in and done substantial landscaping on their land, including on the berm and immediately surrounding the detention basin. I agree and have documented that if you go out there today, there is no forebay present, but what is present is significant vegetation that's grown in the detention basin area that I feel serves the same purpose essentially as a forebay itself. The vegetation that's established itself now is certainly thick enough that it's going to promote sediment fallout so that you're not going to get overflow of sediment through the detention basin and into the outlet structure on the other side. I think the vegetation that's there is substantial and would serve the same purpose as if a forebay had been constructed or was present there today. Again, I note that former as-built that was submitted to this board did indicate that it was there at one point in time, but it appears to have been removed by the owner of that lot at this point.
All right, thank you.
You want me to address each of those three items? Or
please, yes.
Sure. The second one, I believe the peer reviewer was a little incorrect in the PowerPoint presentation that was just presented on item 2, which was the forming of the inverts of the drainage manholes. He was showing a picture of formed inlets at the grates of the catch basins. That is not the requirement of the town of Cohasset, but I believe what he was trying to refer to was in the drain manholes in the street, underground in the bottom of the manhole, in the invert of the manhole, your regulations require that concrete and brick be placed to help direct the stormwater from one pipe into the next pipe. The plans that were approved by this board have specific construction details on them that did not include that as a requirement. So the plans that are signed by the planning board do not have formed inverts as a requirement, but your subdivision rules and regulations do have it as a requirement. So there was a little bit of an error there, and those plans should not have been approved without that requirement stated on them on the construction details. The drain manholes have been in place since the road was built in 2011, 11 years ago at this point. There have been no issues with not having the inverts in place. I would say the inverts aren't in place on drain manholes throughout the town of Cohasset. You don't see formed inverts on many drainage projects. That would not impact the overall design of the system. And then item number 3, which is the stormwater basin, again, on that lot on the left as you go up the subdivision road where the owner has done extensive landscaping. There are a couple of spots on the berm surrounding the detention basin that are approximately 5 inches low in elevation. I would note, however, that the 100-year storm event is contained within the basin. It's been in existence for 11 years without any problems of overtopping or any erosion of any of the berms. It appears to be functioning 100% per design, even though in a couple of spots it is up to 5 inches low in elevation on that berm. That berm does not serve as a weir elevation. It's completely controlled by the outlet control structures in the emergency overflow riprap, which again, that berm does not impact. So those are my quick comments on the 3 outstanding items that were addressed in the peer review.
Thank you. Mr. Reardon, would you like to have any comments?
Yeah, as far as punch list item 10, the second one in the list, Mr. Morse is correct. That should have been formed inverts and not formed inlets. I just went back and took a look through the peer review, and that was my error, that it was listed as inlets in the PowerPoint as opposed to inverts. As far as the first item goes, the pre-treatment, we would want to see for the purposes of making sure that the pre-treatment is in compliance and meets the standards, Massachusetts standards and your town standards. We would want to see documentation of what Mr. Morse was referring to as providing something substantially similar to pre-treatment. So what he described, I think, is a little unusual for pre-treatment, but we'd be certainly happy to take a look at that if you would like us to. And then the last item, 17.3, regarding the berm. Again, we would want to see calculations that support the claim that that this will function properly. The way it is currently, as he points out, there isn't evidence of failure, but that's not the same thing as confirming it through the calculations, which is really the standard.
All right, thank you. Do any of the planning board members wish to comment? Mr. Brewer.
Yeah, I think with these matters, we rely on our consultant to confirm that everything's done, and the expectation is that the applicant, developer, dot their I's and cross their T's to the extent required by our consultant. He's our eyes and ears on projects like this, and his expectations for compliance with whatever's in the approved plans or would be a reasonably good practice would be ours, in my estimation. So substantially complete or mostly done, or it got changed over the years. I just don't think, unless the applicant's team wants to really address an alternate method than what was on the approved plans, then my expectation would be to hold the lot until everything is done to our consultant's satisfaction. But certainly open to discuss that on the board.
All right, thank you, Mr. Brewer. Mr. Grady?
I would actually second what Clark was saying. Actually, he took the wind right out of my sails on that one, so I agree with him wholeheartedly. And I'd be inclined to approve if the conditions that Mr. Reardon laid down were met. But until then, I'd have to have some second thoughts about that.
All right, thank you, Mr. Grady. Mr. Callahan?
I mean, just generally speaking, this is the first time I've dealt with a lot release since I'm on this board, but, just generally speaking, I think we should have strict compliance with the conditions we issue, whether it's on a subdivision, special permit, anything. So if our applicant, if our consultant believes that we need to have these things done, I agree. And I don't, just like the thing we dealt with before this one, the passage of time isn't an excuse for anything here. And I think we should have compliance with the original conditions.
All right, thank you, Mr. Callahan. Mr. Potter?
I don't have anything further to add on top of what's already been said. I think that that's why we have these third parties to advise us on these matters. So it makes sense to me to follow what they're advising and to get that before we make any decisions.
All right.
And I will say one more thing is, if there's an alternative way of doing this forebay because the neighbors messed around with the vegetation, that is acceptable to our consultant, then and I would expect the applicant's engineer to make the case to the consultant so that our engineer is nodding, and then he can tell us everything's been taken care of. Especially if it's a de minimis change or there's good and sufficient reasons for a slight modification. But in the end, we want to see everything that was on the approved drawings done, unless there's a really good reason to do it a different way.
All right, thank you. So, Ms. Lynn, would you provide language for us to segue to the next item?
Certainly. So this isn't a public hearing. There's no, definitive continuation to a time and date certain that's required of this. But what I would do is suggest that we either plan to revisit this discussion on February 9th or February 16th, and I'll turn to Greg Morse actually to give me a preference on that.
If we can continue, well, February 16th, that'll give me time to respond to these 3 outstanding issues and coordinate with your consultant.
Okay, that sounds great. So we'll plan to revisit this discussion on February 16th at the planning board meeting. And in the meantime, I will work with the applicant and our peer review engineer, as well as John Hallen, to coordinate any discussions that need to take place in between now and then.
All right, thank you. Thank you, Mr. Reardon. Thank you, Mr. Morris, and we will see you in a couple of weeks. All right, thank you. Ms. Lynn, will you please tee up the next item?
Yes, thank you. So the next item on our agenda, or the next 2 items, I'll explain quickly. We have 2 items on the agenda. Both are in reference to the property as 26 Lambert's Lane. We first have an A&R application for a division of 1 piece of property into 4 proposed buildable lots, and that is accompanied by a common driveway application. The applicant intends to have a common drive to serve all of the house lots. This application, I'll note, the one that we had received for discussion tonight was the 3rd iteration of previously incomplete and modified plan sets. We have been working with the applicant closely, myself, John Hallen, and other members in the planning and permits department, to make sure that this application addresses all the items that it needs to and that it's complete. For example, the first iteration of A&R plan, while typically zoning is not a consideration of A&R, it's not a determination that the board is looking to make when you have an application before you. As a courtesy, we did flag to the applicant that we noticed that the 3 lots in the back of the lot that he had created in that first layout would have rendered them unbuildable because they had provided the lots no legal frontage. So we did flag that, as a courtesy, and we've been working with the applicant. So you'll hear that this has been going on for quite a few weeks now, and we continue to work with the applicant. We did receive, as of yesterday, a 4th iteration of plan for both the A&R and the common driveway. And I will note that we have engaged Patrick Brennan from Amory Engineers as a peer review on this parcel. He had initially, upon iteration number 3 of these plans, taken a look and done a completeness report to ask for some more information, to which we got a response and the modified plans in iteration 4 as of yesterday from the applicant. So given that we had that receipt of information so close to the meeting time and the crunch between review of staff, the planning board, and our peer review engineer, we reached out to the applicant and we are postponing these matters to the February 9th meeting. I can confirm that the peer review report will be done today. This week. So we'll be able to expedite that and continue this review in time for the 9th. With that said, you don't need to take any action on the common drive application because there's no public hearing required and we have some time to opine on that. The A&R application that was filed, there is a 21-day time clock that ticks on an A&R application. If we, you have really 3 options here, and I will ask council to step in and correct me if I misconstrue anything here, but your options really are to either vote to endorse the plan, vote to not withhold endorsement on the plan, but you would have to specify reasons as to why you were doing that, or you could take no action. Taking no action on the plan could result in a constructive approval because 21 days would have lapsed from the filing of the plan and no planning board action. I will note that, again, no matter what you do here, whether you agree to endorse this plan and reconfigure the lots as such, it doesn't impact whether the lots are buildable. You're not making a determination on zoning, because something that has been brought up by our peer review is whether the width provided for these lots will meet buildability requirements in town. That's yet to be determined, but that is something that will come. And sort of if you approve lots like this, it's not jeopardizing something for the town. It's actually would be sort of a harm on the applicant's intent of what he was trying to do. So we do know that we have a forthcoming new revised plan in both the common drive and A&R. So just I'll lay all those pieces of facts out for you, and I will pause and see if our council has anything that she'd like to add to what I've outlined for the board here.
Marie?
Thank you. Lauren, just curious, since this is the 4th iteration of the plan, is the applicant willing to extend the 21 days for the board to act?
I would imagine that they would be. However, I don't have it in writing and I haven't had an opportunity to confirm that for the board for tonight's purposes.
Okay, so our 21 days is up, not counting this 4th iteration of the plan, but on the plan that was in place before the 4th iteration, where were we in terms of the 21 days?
So let me double check. I believe I'll pull up my calendar. And just to clarify, iteration 1 and 2, because the applications were not complete, were not filed. So those plans, even though they were iteration 1 and 2, are not considered live applications as filed with our clerk due to incompleteness. We filed, oh, my calendar just went away. Okay. I believe that we are on week 2 within a day or two of when the plan was filed. So if we were to continue this to the 9th, we would tick past 21 days from the date of filing.
Okay. Then I suppose one other option for the board is you could vote to, if the applicant is willing to grant an extension offline with directly with Lauren, you could also just continue this to your next meeting, and in the alternative, deny it if there is no extension. Or you could just deny this particular iteration that's before you because you're going to be looking at a new one.
All right, that seems to be pretty straightforward. So Lauren, what do you think the options are negotiating with the applicant to give us an extension that is necessary to be able to consider this without jeopardy? It's a little bit hard to ask you to stick your neck out and say, I'm sure I'm going to get it. So it sounds to me like the safe course is to deny it and know that we're going to be seeing the 4th iteration at the next meeting. That's
Right.
just my recommendation.
What you might I could suggest that based on lack of information at this time and with the understanding that there's been modifications subsequent that you'll be looking at on the 9th.
All right. Does anyone like to speak about this? Mr. Brewer.
Well, I checked the town list and Lambert's Lane is indicated as a public way. Even though it says right here on the plan, it's variable width, but it's not indicated as a public way. But whether it's a public way or a private way, the 4 lots show over 50 feet of frontage, as this is a Residence A district, which 50 feet is the requirement for frontage. It appears that there's access where some of the lots actually seem to be in Lambert's Lane, so presumably that would provide access. There's the lots on the right-hand side appear to have some kind of a wedge-shaped space between the actual roadway and their lot line. I don't know who owns that, if that's a part of the public way or not. I guess I would, if we're gonna deny because they're gonna get a new one, it would be useful for the applicant to get information on who owns that space. Since they may or may not have the right to go across it if it's not a part of the public way. But I see there's the potential for access on a public way, and there's at least 50 feet of frontage. There looks like all the lots meet zoning square footage. I just can't tell if they meet the lot width requirement, but if we're not going to vote on it, or if we're going to vote to deny endorsement, then I guess it doesn't matter.
All right, thank you. Mr. Callahan?
And I don't think this applicant has given us any choice tonight but to deny the application.
All right, thank you. Mr. Grady?
I would agree with Tom and Clark.
Thank you. Mr. Potter?
I agree with everybody.
All right, thank you. I agree as well.
All right.
So can I get a motion to deny?
I'll make the motion to deny.
Second,
All right, roll call. Mr. Brewer?
Aye.
Mr. Callahan?
aye.
Mr. Grady?
Aye.
Mr. Potter?
Aye.
Amy Glassmeyer, aye. Thank you very much. All right, so we are really doing well on time tonight. So as we have previously organized our recent meetings, we can move directly into the next item, which is set as time for 8:30 p.m. Is that correct, Lauren?
Yes, that's correct. It was continued to 6:30 p.m. with the caveat that the advertised continuation time may not match the published time. So we are all in keeping to reopen this public hearing at this time.
All right. With that, Ms. Murray, do you have any introductory comments that you'd like to make about this?
Not at this time, Madam Chair.
All right. Then I will ask, well, Mr. Callahan has gone away. I was going to ask Mr. Callahan if he'd like to start the discussion on item public hearing pursuant to MGL Chapter 41 S81Q for proposed amendments to the Planning Board rules and regulations for common driveway minimum standards. The proposal is to rescind the existing common driveway minimum standards to be replaced with new language titled Residential Property Access Regulations of the Planning Board for Non-Subdivision Controlways. Thank you. Now, Mr. Callahan is back in his chair, and I would ask him to begin the conversation.
Okay, thank you, Amy. All right, so before us is the proposed regulation on residential property access meant to expand upon and replace our existing common driveway regulations. I'm looking at the red line version that came from Carolyn. I have it up on my screen just so I can see it in large enough type. I was going to work with the red line version because there's a number of comments by both myself and by Carolyn, and I think the best thing to do is to just go through this section by section. And as we go through each section, I would propose to solicit comments from other members of the board and then members of the public. going through it section by section. So to begin, the first is the background and purpose, which I believe we have in the current regulation, but this explains the purpose of this regulation. And in the broad sense, our current regulation just regulates common driveways. Our subdivision control reg section, chapter 325 of our bylaws deals with subdivision roads. What we don't regulate is the private way that is something more than a common driveway, but not an approved subdivision road. So one of the purposes of these regulations is to address that gap and to put in some regulations for the many private roads in town that are not actually subdivision roads. So with respect to the explanation, I think it's pretty straightforward. Carolyn's changes to this section 1 are fine with me. I don't know, again, I'll open it up to anybody's comments about that. And I guess, in following Amy's lead, we'll proceed in alphabetical order. Well, all right. So Clark, anything on section 1? Or anybody?
Well, I mean, I know you've been working on this stuff for a while. It's just that I see that this is taking away sort of flexibility that's inherent in the common driveway standards, as well as grabbing more regulation on private ways, that not the subdivision ways that were not accepted as public ways, like Hillside, where you live. Those seem to be adequately constructed and not have issues. But there's all these ways that predate zoning that look like common driveways, but aren't. There might be 20 feet of way to them instead of the 40 feet. And I think this overregulates the an aspect of Cohasset, a necessary aspect of Cohasset planning that responds to the environment that we have. Cohasset's not on a grid, and we have wetlands and ledge. So I would like to see an update to our regulation. It's just that the purpose, I think there's that this needs some more work, and we don't seem to be representing best practices in those guides that I'd referenced and forwarded. Well, I'm happy to see what might make sense from a big picture. But it seems like the regulation that you've drafted, Tom, it's deep in the nitty gritty. And I want to make sure that we have the big picture as well as the details correct and how much we're going to regulate. So those would be my comments on number 1.
All right, let me, I didn't want to bring this up, but I'm going to bring it up. The zoning board turned down your special permit application to build another house on this property. Are you still pursuing that?
I'm not going to comment on some other matter, Tom, but like I said, when we opened the hearing on common driveway standards, I have a lot. It's protected under Mass General Law 41, 81 FF as an approved subdivision. And in the late 40s, a land court judge approved access via something called a traveled way.
Okay.
My access to my lot, that's actually, it's already developed lot, it just doesn't have a house on it, is not affected by anything that you do here.
I would disagree with that, but
well, land court does supersede planning board, and I'm sorry if you don't believe that.
Eric, I know you wanted to say something.
Yes, and I changed my background because I saw Clark and Amy's were blurred, so I just want to
I make sure we weren't going to disappear and you were going to go to the beach.
That's where I'd like to be right now, but that's a different story.
Yeah, wouldn't we all?
So generally speaking, I don't want to get clouded by Clark's. I don't even know the specifics of it all, but I don't want the board to get clouded by this. I think my bigger concern may be the one that we perhaps should discuss, and that's the fact that we do have this comprehensive zoning bylaw review coming up. My concern with these regulations is number one, perhaps perception of how this will be received by the general public by taking regulations into hand. And I know this frustrates you, Tom, but if we do have a zoning bylaw review coming up and a comprehensive review coming up, my question would be, and I'd like someone to give me a direct answer to this: why would we do anything with regards to zoning when it's already been something that's been discussed at town meeting, that there's going to be a comprehensive review of the zoning bylaws without some sort of palpable or identifiable emergency in place or public need to review a specific bylaw? And no one seems to be able to answer that question.
I'll
give an example.
Okay, so just
First of all,
I want this to be cordial, and I want it to be.
Yeah, I want to be cordial, but it's
I
not.
intend to be cordial, okay?
Okay, so thank you, Eric, and Tom now speak. And I'll go to
If people want to tie in what happened at special town meeting, then they need to hear what needs to be said. The zoning, this idea of this regulation isn't mine personally. It did arise out of the work of the zoning working group, as well as the work of this board in addressing challenges that we are facing. Clark distributed a memo on the 16th. I had written a response to it. I calmed down and did not issue it, but it seemed to imply that the only reason we should be doing anything is to respond to a problem, and I emphatically disagree with that. I'm gonna, if you don't mind, I'm just to refresh my increasingly addled memory. What I was going to write in response to Clark is that I don't think that we have to always draft something, be it a regulation or a bylaw or state statute, federal statute, in response to a problem. There's other reasons why you pass laws and regulations. One is implementing best practices. And I'll speak to the materials he distributed in regard to that in a little bit. Second is in eliminating ambiguity. And the third is to be preemptive and address an issue before it becomes a problem. Now, the reason this is being advanced, well, let's just say on the zoning working group, we come to the conclusion that we are not going to do an entire rewrite. Right now, the bylaw has 22 articles. We're not going to present the town the whole thing in one fell swoop. It's going to come in phases. And at special town meeting, a phase that we thought we needed to do that relates to this regulation is to clarify our definitions of streets and ways and the adequacy of them. And if you need to have it respond to a specific problem, well, as we've confronted what's gone on in Black Horse Lane, now Cedar Lane, potentially Dolan Lane, Tad Lane, Ocean Edge Drive, whatever, we are having the pattern of development in Cohasset is at the point where what is now being developed, because of the great value of land, are lots in the back lots that are off old ways or old common driveways and cart paths. And if you will all recall, back in the fall when we saw an A&R for Black Horse Lane, we all had a problem with what was there, which is what, a 6-foot wide piece of pavement. As a matter of fact, Clark, you were the first one amongst all of us who said, I would move to deny this. And then the applicant withdrew it rather than face that. So we all know that this is an issue. And our common driveway regulations, again, the standards for construction are taken from what we have today. And with regard to Clark's materials about low impact development and these newer trends and things to think about, I got a chance to quickly glance at them. And I didn't see that they deal with dimensions and construction requirements. And so I don't think that adopting quote unquote low impact development standards is inconsistent with what's here today. And I'm not suggesting that we couldn't tweak what's written here to incorporate some of that. But
Listen, Tom, just a quick comment on identifying what problems that there exist with private ways or common driveways. I think that the important thing is that we have a bylaw that works with what the actual problems are that people are facing in these very specific types of access routes.
well,
Not that we don't have to do anything if we can't identify a problem, but the identifying the problem helps with the response and the design for the regulation that you're proposing.
again, it's not, this proposal is not designed solely to address a quote unquote problem.
I'm not saying that. I'm just saying
It is also
problems inform
intended
the
to, it
solutions.
is also intended to update our regulations, to employ best practices, and to preempt potential problems. The issue that we're presented with the roads that I mentioned and can be expected to confront in the future is whether they are adequate and safe for use, for the use intended. And with all due respect, Clark, you're on record that you think your road is adequate and safe, and I would wholeheartedly disagree with that.
Well, I'm not sure what you were referring to, but in terms of
I
emergency vehicle
listened-
access, there has been no issue with Dolan Lane. But I think
Okay.
it makes sense to keep my little private way. It's not a common driveway, but it's a private way access out of this discussion.
Well, well, I'm sorry, it creates the appearance.
Okay,
Can I
then
just-
we can talk
can I just
about
make- can I just make three quick
Hillside
points?
Lane as an
Excuse
example
me,
for planning
excuse me.
purposes on how you
Excuse-
deal with
All
a
right,
private
stop.
way
Point of
regulation.
order for both of you.
Is there
Clark,
someone yelling?
Order. This is not a debate
What?
about individual properties right now.
Well,
Yeah,
I
exactly.
suggested that we
This
keep it
is
out
a-
of, we keep
this is-
the individual house out of it, because
I'm going,
Sorry.
Clark,
Mr. Brewer.
Glassmeyer lives on a private way as well.
Clark,
I-
Clark, I'm not gonna, I'll not bring up the issue. The issue needed to be addressed of a potential conflict. You've made your
Okay.
point, I've made my point, we'll move on.
Can I just have a chance? Can I just have a,
Let me try to explain.
Member, point of order for all of you. I want to ask other members of the board
Well-
for their opinions. So, Mr. Grady, would you like to offer some commentary?
Well, I wasn't
I'm a-
finished explaining to Eric what this was about, but that's okay.
and I was just looking to have a conversation quickly with Tom. That's all it was. It was, I just have, and I'll be quiet after this.
No, and I'm
three
trying
things
to, I'm trying
three
to
things-
explain to you the motivation for this proposed change. And it's not,
Right.
it doesn't lend itself to a quick soundbite or a quick answer. But
That's fine.
we-
I respect that.
We are, in a nutshell, we on the board are confronting issues of adequacy and safety in many places in town, and we will continue to do so, given the nature of access and roadways that the town has developed over the course of time. We have a construction standard for common driveways that is in our regulations now, and it is transferred here. That same construction standard, in consultation with the head of our DPW, is brought over to the non-subdivision private road. Now, where we have no regulation. Now, the second point about the common driveways is, yes, right now you can use a common driveway to access 8 lots. It is reduced to 3 in this proposal. We are an outlier in the town of Cohasset on that point. in this area and in other areas where the town is an outlier in our zoning bylaws. I will tell you that the working group is looking to not make us an outlier on our zoning bylaws anymore. This is one. The common driveway at 8 lots is an outlier, and it is, in the opinion of myself and others, an end around the subdivision control law, which, as you all know, would require a road of a different dimension and a different construction standard. And so we are in this regulation setting a tiered system that you have common driveway, can serve X number of lots, be so long. The non-subdivision private road can serve so many lots, be constructed a certain way, be so many feet in length. And then the third at the top of the hierarchy is the subdivision control road, which will come from an application under the subdivision control law. So this was done in consultation again with our DPW head. He was very influential in putting in the specific criteria of construction and drainage. But, you know, again, we're going to get off going over this section by section, but
Well,
the.
Paul Grady wanted to make a comment, I think, a couple of minutes ago.
Yeah, all right.
can
I was asked to make a comment, but I keep
Can I
getting.
make my
interrupted,
point?
so let
Point of
everybody
order.
finish.
All right.
It will be Eric Potter, then Paul Grady, and if Clark and Tom can't calm
No,
down.
I'm-
I'm gonna ask
I'm
Eric-
not
ask-
having an issue.
No one's acting
I'm
crazy.
asking you both to
I've got no
just
issue.
let
I am
others.
finished. I am finished with my initial answer to Eric's question on why this bylaw is being proposed in the way it's being proposed.
All right, thank you. Mr. Potter?
I'll be quick. So Tom, I see where you're coming from. My point would be this. It does appear by doing this through a regulation that it could be backdooring what was otherwise voted down at town meeting. And I know we have the rights to do this via regulation. I think the planning board has a big problem in front of it in that we need to have the public support to come back to our side. And especially with the zoning bylaw review to take place. I don't think that one project necessarily, or even two projects that were slightly problematic with regards to what these regulations would cover, rises to the level of being a exigent circumstance that would necessitate regulations to be revised. That's just my opinion. Everybody can have their own. I do think that with the zoning bylaw review coming up in the near future, it does appear that we're cherry picking here. And that we're putting a regulation in place when there's going to be a lot of time for this to be handled in that zoning bylaw review. And it also does appear to some, not necessarily me, but that this is a way of backdooring something without any real significant issues or projects that have been problematic in the past, other than the few that you've named. Those are my concerns. That's why I'm hesitant to vote on any regulation absent some sort of clear and apparent need for the planning board to take action prior to the comprehensive zoning bylaw review. That doesn't just extend to this, it extends to really all of our, any matters that would relate to changing regulations or bylaws prior to that comprehensive bylaw review. That's just my position on it. And I get, that's my concern as well, especially moving forward when we're gonna want the public, the citizens of Cohasset, to have confidence that planning board is acting without any bias, in the best interest of the town, and being transparent in everything that they do, and cherry picking, quote unquote, while not necessarily the case here, there could be a perception that that's taking place with regards to why this. There's a lot of things to do. There's a lot of action to take. That's why I'm concerned with it, and for no other reason.
Well, let me just respond to that. First of all, that the.
Tom, it's Mr. Grady has a chance.
No,
He-
why don't we let Tom respond? This is getting old, so let him respond. I'll say my piece after he's done. No, please, just respond. Just address
First of all-
Eric's point, Tom. So then I'll get to my point, then we can eventually hang up the phone.
This change is useful to us as a board whether the bylaw changes ever or not. It is not dependent on a change in the bylaw. It is not dependent on the change in definitions that were, which, by the way, was all it was a change of definitions and twisted into something else at town meeting. And you're agreeing with me that, well, except for those things you brought up. Yes, except for those things you brought up. We are confronting this issue of adequacy of the access for development all the time now because of the lots that are being developed. And we need this change. We need to have some standards because right now we have none. And when we sat there with Black Horse Lane back in the fall, we didn't know what to call that, a common driveway, a cart path, and we didn't know what to do with it other than to deny it. And how do we determine whether something is adequate or inadequate? The case law lets us make that as a subjective decision. This is trying to help us to give us some objective standards by construction and design for us to make the determinations that we are increasingly being asked to make. Paul, I'm sorry, I apologize.
Nothing to apologize for. The 2 points. I agree with Tom in setting some standards, things that can be changed, but I think we should have some standards we should go by. I'm also, and this is not an accusation, Clark, because I'm not going to get involved in that. Even on this board, if there's any hint of conflict of interest, and I'm not saying there is, I am not saying, again, I'll emphasize no accusations.
There isn't.
But if there is the hint of it or something get out, like for instance, the Pleasant Street project, I recuse myself, even though it's more than 500 feet from my house. I don't want impropriety on the board. If I have to step back, you step back. I'm not saying to you, I'm just saying that this board should not have that. We've got a lot of important things in front of us, things changing, hopefully for the better, different times. But I don't think
Yeah,
that it's
sure.
right that
More than half of the board lives
that
on a private
anybody
way.
should have, no other person in the public should have someone to hang their hat on in any regards, and that means all of us on this board. If there's something that they can hang their hat on and blame for something that may or may not happen, is what I'm getting at. I'm not being case specific, but I'll bounce back that I do agree with Tom that some standards should be set. We should have some rules to go by and some things we can reference to, and that town meeting is town meeting. But I'm also believe that the town should be made aware of every change and or proposed change. But that's where I'm going with the conflict of interest.
There is no conflict of interest for me.
All right, if you feel
But I
that
do
way.
have a full-scale model of a private way that I understand how Tom's regulations would impact somebody that lives on a way like mine. And that's very useful. And one of the things that I guess to continue the conversation that I think makes sense is to do some test cases with Tom's regulation to see how they might play themselves out in maybe significant or insignificant locations, and inform what the regulation is with real world test cases. I think is a useful exercise prior to passing a regulation.
May I also, I want to Clark's point, and again, skipping around, this regulation will set standards for the construction and design and length of common driveways and non-subdivision private ways, number one. It will create a process, and I'm doing this for the general public's understanding of this. It will create a process of how adequacy can be determined with those construction and design standards being a presumption of adequacy. I think the thing that is controversial and which creates the potentials of conflicts of interest is that this regulation would require, first of all, it would not require any existing common driveway and non-subdivision private way to meet these standards unless there is new construction added to that road. I have an issue with one edit that Carolyn did that I was just reading. It's this example with Lambert's Lane. This is a new common driveway to be built from scratch. That new common driveway, any new non-subdivision private road would have to meet these regulations. But as for the existing on the ground today, the design and construction criteria would only have to be met if there is an added dwelling, meaning an added use to that driveway or roadway. And I understand that that would be the controversial part, because it is the person, what the regulation is proposing is that the person who is responsible for the added dwelling would be compelled to do an upgrade if, and that is a big if, the planning board and or building inspector were to determine that the driveway or the way is inadequate. So in a real world example, if I'll just pick a road. I'll make up a road. We have A Street, and it's currently serving.
Well, Tom, my idea was to use real world examples.
All right.
But we may not be able to get to that right now.
Well, no. I want
the point you're making is who pays. That's the and
Well,
what's the risk to the general public?
I'm trying to explain.
I'm sorry, let me just finish. It'll only take a minute. There is a mass general law for private ways. I think it's 84, section 13, that if 3 or more owners on a private way want to upgrade or pave or maintenance or put in drainage, then all the owners would have to pay. Like, so for using your hillside street, if it's time to repave, if you get 2 of your neighbors to agree to repave, all of your neighbors will pay. That's a mass general law. And the same could be true of applying these regulations to one house. If a developer has a house lot and he talks 2 of his neighbors, I'll pay for your share if we can get the rest of the 10 people to pay for their shares of upgrading the road in conformance with these new regulations. There is an element of potential expense for the hapless homeowner who happens to have a neighbor with an extra lot.
Just very quickly before Tom goes on. You talked a long time. This is just like Paul is stating about Clark potential conflict of interest, which I agree with Paul. Hey, listen, if there's a hint of conflict of interest, you should step aside. But this board is sitting in a glass box. If they think that the perception of many citizens in towns is that it is anything other than the fact that this board is taking action to limit development, which at town meeting, there were votes that took place that can be interpreted as meaning that to shoot down a board that is overstepping its boundaries with regards to some potential zoning bylaws. Now, if the board wants to have the support of the citizens when we do a zoning bylaw review, it would be my recommendation, unless there's some sort of emergency or something that is clearly needed to be reformed, to hold until a zoning bylaw review happens. You have to look at it because it just, you don't understand the perception of, let's say, 50% of the people out there. And I don't want to be a part of a board that is looking at things as is being seen as anti-development. Nor do I want to be part of a board that's looking as seen as develop the whole town. I want to be part of a board that is unbiased in its decision making. The timing of this is the problem. Tom, I agree with the regulations. I think they're great. The timing is what I have a problem with, and I'm telling you this. If you move forward with adopting these regulations, it's not going to help the way in which this board is currently perceived by, and what's going to happen in the long run is that when you do your zoning bylaw review, it's going to be even more scrutinized than it already is going to be. And it's going to create further problems because no one has yet to show any real issue with leaving things as is until the zoning bylaw review happens. And in fact, this was kind of proposed and shot down in the comprehensive bylaw that was going to change definitions
No,
and such. But
Clark-
you guys, if you want to go that route, you go that route.
Well, I'm going to do this, Eric. I feel the need to address misinformation about that. First of all, this board is not anti-development. The zoning working group is not anti-development. And the vast majority of speakers at town meeting were developers or people who have development interests on small amounts of property, including one from out of town who's here waiting to speak tonight. And we're going to let him speak because he owns property in town. We had people who did not disclose their interests in defeating what were mere definitions that state law already imposes upon us to apply.
Listen, Tom,
And-
the
and
master
look-
laws were misquoted and the Supreme Court decisions were misquoted in that.
Oh, stop
in
it, Clark. They weren't, all right?
and-
I'm not going to
yeah.
argue. Clark,
They
I'm not
were.
going to argue
And-
with that, with you here.
And
all
I'm
right?
embarrassed for you to have done that.
I would like to stop this right for a minute. And I'd like to take some comments from the public because we're at loggerheads right now and we're not making progress. So let's inject some other insights and then we'll come back and have further discussions from the board members. Lauren, will you please promote individuals?
Certainly, yes, thank you. First, we're going to hear from Matt Watsky. And for all members of the public, I see there's a couple of hands raised. When I do promote you to use your microphone and camera, please state your name and address for the record. And if you don't have an address in town, just please state your affiliation.
Lauren, how many people do we have?
There's just 3 people who are wishing to speak right now. Matt Watsky, could you please state your name and address for the record? And if you're not a resident in town, could you just disclose your interest?
Yes, good evening, members of the board and the public. And Lauren, thank you for promoting me to be visible. I'm Matthew Watsky. I'm a lawyer. My law offices are in Dedham, Massachusetts. I reside in Westwood. I'm counseled for Chip Smith, the applicant for the preliminary subdivision approval for Black Horse Lane that was voted on this past month, and on which we're working on the preparation of the next round of plans to submit to the board. To the extent that this kind of rule has been presented with the idea of trying to block certain projects, and I'm not suggesting that it was directed specifically at Black Horse Lane. It is not going to have an effect on that because this is in essence a zoning change under the authority granted by the zoning bylaw, and by having filed the preliminary subdivision application, this project or this property would be under the benefit of the zoning freeze, both the process freeze and then ultimately we would hope and expect to have an approval that would have the long-term freeze. But because this discussion's going on the way it is, it really pushed me to take a closer look at the proposed change in the rules and the foundation for it, the zoning bylaw. So the first thing that I do when I look at a set of proposed rules and regulations is what's the authority that the board or the agency has to adopt the set of rules? Because just like a state agency, whether it's the DEP or some other agency can adopt rules and regulations, they can only adopt rules and regulations that are consistent with their legislative authority. The planning board's authority to adopt rules and regulations governing common driveways comes from the zoning bylaw. You've got section 300-7.3 subsection D, which is that common driveways servicing 3 or more lots may be permitted, and I could share my screen and you could read it, but servicing 3 or more lots may be permitted by a majority vote of the planning board if it's clearly demonstrated that improved use of the land, protection of wetlands, or similar public purposes are served. In improving a common driveway and setting conditions thereon, the planning board shall consider the character and intensity of the uses to be served by the proposed driveway, the traffic safety, ease of access at street and highway entrances and intersections, as well as the safety and access to the uses served. And for the purposes of this subsection, the planning board shall, after public hearing, adopt reasonable rules and regulations for the construction of common drives and shall amend such regulations in the same manner. There's a bit more that it goes on, but so the most important part of that for purposes of the discussion tonight is that it's common driveways servicing 3 or more lots may be permitted by majority of the planning board. So just taking it on a very high level, the key things that your proposed set of regulations attempts to do is to clarify the definition of a common driveway, clarify, I'm putting, I guess, in quotes, to say that it's any driveway that serves more than one lot. And that's beyond the scope of your authority under the zoning bylaw. The zoning bylaw says a common driveway is any driveway that serves 3 or more. And it authorizes the planning board to adopt rules and regulations for common driveways that serve 3 or more lots. So you don't have the authority, in my view, to adopt a rule that says that you have authority to regulate a common drive that's accessing only 2 lots, because that's inconsistent with your zoning bylaw. I think it is also ultra vires is the Latin expression, but it's also inconsistent with your rule for you to adopt a rule that limits the number of lots that can be served by a common driveway to only 3, because the zoning bylaw says it's 3 or more. So I can appreciate that you perceive a problem in the town that you have common driveways accessing too many lots, but that's a problem that has to be addressed by your zoning bylaw, which is the enabling act that's enabling the planning board to adopt a rule or regulation that's regulating common driveways in the first place. If we go past that, and I don't want to go on.
Is there a time limit?
There are other issues. Those were the key things that I wanted to point out. You do have numerous other issues in this set of regulations that you should consider. For example, there's the specific about the type of surface course and the binder course that has to be provided. And it would appear, the way it's written, to prohibit the use of pervious pavement. Pervious pavement has become very common these days as a way of properly managing stormwater. You have a provision about any common driveway shall include maintenance and snow removal plan. I don't see any legislative authority to empower you to do that. You have some inconsistencies. You create presumptions in Section 5 permitting issues. You say that there's a presumption of adequacy, but it can be overcome if the public safety or public works department's a certain objection to the adequacy, or someone determines that an upgrade is required. So how is that a presumption? You create a presumption except if you determine that an upgrade is required anyway. So it's a presumption that isn't a presumption if you decide it's not a presumption. That's not clear rule writing. And it's the kind of thing that, because it's so vague and ambiguous, it will be subject to overturn.
Okay, thank you, Mr. Watsky. I want to move my comments to Ms. Lind, but we appreciate the comments that you're making. Ms. Lind?
Yes, I just wanted to note that we do try to keep folks to a 3-minute maximum, and I believe that we've gone beyond, but thank you very much for the commentary. I'm going to move on to the next. We have,
if I may, I'd be glad to submit something in writing to give you a summary of each of the issues.
So,
if the board would
Thank
like.
you.
I just want to assure.
Paul, but I did say, Paul, that we were going to take comments from the public. So
we're going to be lectured to.
We're not,
This
no.
isn't being lectured to,
No,
it's just
we're not.
ideas.
Lauren, can you please promote the next person?
thank you,
It's
Mr.
just ideas
Watsky.
and
Any comments
expertise, and there's nothing wrong with that.
for any, just for
Someone
the
is
record? For
representing
any public record?
representing another project that's grandfathered in.
Let's
Telling
move.
us Cohasset
It doesn't
is
matter where
wrestling
comments
how
come
we're supposed to
from.
run this town.
Paul, can you please let us continue? Thank you.
So thank you, just for the record. So for public comment, we are we are supposed to take any member of the public. We've had asked this for council before, so that is why we take commentary. So we will try to ask people again, please not to be repetitive for points that have already been made. Please try to keep to a 3-minute maximum. At any time, any members of the public are more than welcome to submit letters or comments or any sort of information, whether it's via a public meeting or while a public hearing is opened. You can submit to the planning board office. I'm Lauren Lind. So I'm going to move on to our next comment.
I'm also setting a timer so that everybody that's going to speak will know that now.
Sure, I will set a timer when they begin speaking. And then, so we have Barbara O'Prey and then Steve Bjorklund would like to address the board. There's no one else in the audience that has raised their hand. There is a comment then. I'll just state this now. Tanya Menchie at 25 Tad Lane. I only want to comment that since this is a public hearing as a town resident, I'd appreciate hearing all public comments without interruption or disrespect from board members. Thank you. So I'm going to move on over then to Barbara O'Prey. Could you please state your name and address for the record, and please try to stick within the guidelines that we've set out for public comment.
Barbara O'Prey, 172 Beach Street. I'm having a hard time understanding the rationale on the common driveways. You're saying you want an 18-foot driveway, which is, I think, about 1.5 times the normal driveway. Certainly wide enough for 2 cars to pass because Beach Street isn't even that wide in places. But still, you're saying you want a 3-foot shoulder, which means taking down a lot more trees probably, and a 40-foot right-of-way. And to me, that seems pretty excessive since most of our roads have a 40-foot right-of-way. Why is this necessary for a driveway that you say is going to serve only 2 to 3 houses? Could someone explain the rationale?
I'll explain it that again, the construction and design standards are what are set forth in our current common driveway regulation for the, again, because today we have up to 8 lots. We have a graduated schedule, like for 1 to 3 lots, it's a certain construction standard. I think 3 to 5 is another, and then over 5 is another. We took the middle one at the recommendation of our public works head, and to help for what they need to do with respect to drainage and snow removal, and then the access of public safety vehicles and fuel delivery vehicles. So it wasn't made up out of nowhere. It was taken from our existing regulations and applied to both the common driveway and to the non-subdivision private road. Again, that construction standard would not be required to be applied to existing roads and driveways as long as there is not an addition of usage by the building of a new house. So everything is grandfathered as a general rule. And if the road is the driveway or the road that we're talking about is also deemed to be inadequate. So there would be no need to upgrade to this unless there is both an addition of use by an additional dwelling and a finding of inadequacy of what is there on the ground on that particular street. So it will always be case by case, but it's not going to require anybody to change anything as long as there's no new usage, added usage to a particular road. And, and for example, again, if I may, with real world example, Dolan Lane is a narrow roadway. We all know that. It has what now? 2 houses, perhaps 3. I'm not sure what's been built.
3. There's 3 houses. I live there.
I know you do.
I live in one of them.
Now. There's 3 now, and there's the possibility for 2 more, as far as I know. And so the question will become, if those 2 houses were built, adding to the usage and the demands on the road and the safety and access requirements, should that road be upgraded or not? If there is a determination, and there is a process to make that determination set forth here, then there is going to be a certain construction and design standard taken from our existing construction and design standards. So, I want to explain to Mr. Watsky that this wasn't designed to stop what's going on in Black Horse Lane. And to the contrary, when this was first presented to us as an A&R, there was concern that there could ultimately be, I think, 6 or 6+ houses being served by what then was proposed, just to serve by the existing 6-foot wide piece of pavement. So to the contrary, we wanted to see whatever was going to happen on Black Horse Lane have a better access. And you know, now the current proposal of Mr. Smith is to indeed provide that better access for the degree of development that is potentially capable up there. So
Do we have other public comments?
Just a minute. Do we have any? We have one more, right?
Dr. Prey has
No,
something
you
else to
didn't
say.
answer my question. My question was, why do you need a 40-foot right-of-way for a common driveway? I wasn't talking about Dolan Lane, which is a state road. I was talking about a common driveway.
I'm suggesting to you, I'm telling you that the design standard set for a common driveway exists today in our current common driveway regulations and has existed in that form for years, decades.
I look at.
All right, let me say that for our next speaker, as we've had multiple interventions by him, I hope that the information is new that we're going to hear that will help us.
Steve.
Yes, sorry, Zoom is just,
Sorry.
there we go.
Doing this correctly? Can you hear me now?
Yes, we
Yes, we
can.
hear you.
Okay.
Steve, could you just state either your name, address, or affiliation, please?
Yes,
Thank
yes,
you.
I will. Absolutely.
Thank you.
I'm Steve B. Orquand. I'm a property owner in Cohasset. I live at 861 Main Street, presently in Norwell, but was spent most of my life in Cohasset, and I think most of the board members have heard me speak before at this point. And I just want to bring up, and I'm not going to reiterate a lot of things that happened already this evening and a lot of the discussion, but I think right now Cohasset has a great common driveway bylaw. I think that the misconception here is that common driveways are certainly different than private roads, and they are treated differently as private roads. Although the fire department and the building inspector are presently the ones that determine whether or not there is adequate access to lots that are being served by those driveways and or private roads. What's happening here, and again, clearly town meeting voted down what we're looking to do right now. And they're right that a 2-lot driveway is referred to as a shared driveway in Cohasset. And I have built and worked on a number of common driveways that worked out perfectly in Cohasset. There was no problem with them. They're very safe. There's been no issues that I know of. This is clearly an attempt to have a 5-member board vote with 3 members to overturn what the will of town meeting was on a zoning article that they did not pass. They're
Mr.
asked to
Borkland,
look
you
at
don't
this
have,
as a zone.
Mr. Borkland, you do not have evidence for that. So why don't you?
I was at the town meeting and I spoke at the town meeting.
I understand that,
was-
but you don't know who's going to vote what and everybody's opinions. So it's unnecessary for you to say that.
It was already voted. It was voted down at town meeting, correct?
All I'm saying is you don't know what the individual members on the planning board are going to do.
I'm not talking about the planning board. I'm talking about town meeting voting this down. Okay, well, you have the authority right now to vote this thing through. If 3 of you guys want to vote it through, have at it. I personally believe it's the wrong thing to do. It's not the sentiment that town meeting set by not approving this at town meeting. That's what the comment I was making, and I'm not being argumentative. It's a fact that it was turned down, okay? But you have the power to pass it. You could shut everybody off right now, vote it through, we're done. We'll deal with it at that point. But what's happening is the planning board is now taking the authority over single lots on private roads that have no division of land, okay? No division whatsoever of land. Because if there is a division, you already have mechanisms in place to provide that access. This is taking over individual protected lots and now saying that the planning board is going to be the one to determine if that existing road is adequate access or not. Court cases will go on and tell you that it's been up to the fire department and the building inspector. So what's being asked right now is to give that authority to the planning board. Tom won't disagree with that. That's exactly what it is. They want authority over every lot in town. You can do it if you want. I personally believe it's the wrong thing to do. And that's all I really want to say.
Thank you very much.
You know, Steve and I have tangled many times over the years.
Are there any other
you know
public
what?
comments?
Let's not tangle any further.
No,
Are there any other
I
public-
don't
Are there
want
any
to get
public
into
comments?
but I won't stand for mischaracterization of what's trying to be done.
Tom, can we redirect here? Are there any other public comments?
There are no more public comments. There's nothing in the
Right.
Q&A and no one with their hand raised. Thank you.
Okay, so I mean, the issue I have is going back to the summer when I had a chat with the preliminary stuff that was proposed for fall town meeting. Is that Tom sort of writes these bylaws and then is unbelievably inflexible when you bring up any then attacks and you know, it's unnecessary. I think that updating these regulations is fine, whether it's a part of the zoning, comprehensive zoning overhaul or outside of that. But what we want to do is to make the best regulation that we can that's targeted for the issues that we have in Cohasset. It's not a bottom up, attorney doing design problems. It's a top down with the big picture and bottom up for details that really is the best solution for Cohasset and is workable and complies with the laws. And I think Attorney Whatley makes a good point that we can't stray from what's in 7.3 Section B in terms of the writing of this regulation. It has to conform to what's in the zoning bylaw.
All right, so I can say at this point that I feel we ought to take a rest here and
That sounds great.
and continue this public hearing at another time because we are not going to find a reconciliation amongst the members of the board at this moment.
I'll make a motion to continue. What's the best date?
Well, I guess, may I make a suggestion? Let's just clarify the pieces of information we want to obtain and run by council between now and then. And that way we can have a concrete plan about what we need and what we need to circulate so people can look at it in advance. Can we make a list of what, just concretely again, so we're all clear on the same page? And then based on that list, we can then determine what date would be appropriate.
Well, couldn't we just continue to our next meeting and then,
Can I make
it
a
seems like there's a
suggestion?
lot of work to do on these.
Can I make a suggestion?
votable.
Can I make a suggestion? please?
Go ahead, Mr. Callahan.
Since I'm, this is being tagged.
You're the
as my-
author of this stuff.
Well, I resent the fact that this continues to be tagged as some personal agenda of mine. I am working here with other people and in the best interest.
I know,
of-
Tom, you're trying to do the best thing for the
All
town.
right, you know what?
You are being incredibly inconsiderate.
No, I'm
gonna
not.
get
I'm
into-
actually
Clark, let him
complimenting
speak.
Tom. I'm
Just let
complimenting Tom.
Clark,
You
let
have to
Tom
listen to
speak.
that.
But as the one member here who is presenting this, I want to make the following suggestion. First, that we not take this up earlier than our first March meeting because it isn't going to get pulled together in a week or 2 weeks. Second, Carolyn has already looked through this and Carolyn has given opinions on it. There's new stuff in here, on the process and the upgrade requirement. And, my belief, it was already vetted that those were all okay legally. Attorney, I know Matt Watsky, I'm sorry, Matt, I missed your last name there. But he brings up a point about the authority deriving from the bylaw. I agree with that from a legal perspective. And I would just ask for Carolyn to opine on that. And if that is an adequate position or a correct position, then we need to redo the whole process has to be redone and started over again. That's the only thing that I see that we actually need from Carolyn at this point, because she has vetted everything that's on the paper up to this point. The second thing, Clark, to the extent that, like I said earlier, the low impact development stuff, and there was one of them, the MAPC's presentation of the slides that's not widely used in Massachusetts yet.
TTPC has a couple of guides too.
I get it. I understood that. I looked at those, and in quickly looking at them, I didn't see that any of them set forth any particular design and construction criteria. But I'm going to ask.
Top down and bottom up.
I am going to ask.
I want to stop this because not all of us read that material. It is not something that we can absorb. Really, no. I mean,
continue this. Let's just continue to March.
I am trying to get us to.
You want me to get to March? I was trying to make a motion. Let's just continue.
I am trying to get us to the point of continuing this. So in continuing this, Carolyn's opinion on Attorney Watsky's points. Clark, I'm going to ask you to work with me with these low impact design things of integrating it into this. Don't cover your screen. I'm asking you between now and the next time we just deal with this, you work with me.
Sure, I'm happy to work with you, Tom.
Fine, thank you. That's all I'm asking at this point. And then if any other members of the board or the public wants to comment on a particular section and their concerns about that, but I do want us to get beyond the point that this is a backdoor attempt at what happened at town meeting. It isn't. As I said, these changes could help us today under our current rules and what we're dealing with. And if everybody understands that, we can go forward constructively. Come March, I may agree with everybody that we put this off. Carolyn may say we legally can't do it and agree with Attorney Watsky. But between now and then, let me work with Clark, let me work with Carolyn to address those issues.
All right, thank you for that intervention. Lauren, how difficult would it be to have somebody actually look at the common driveways that we have in town and actually do some kind of assessment of their condition?
Do you mean like to do an inventory of the existing common
do
drives
we,
in town?
this would be a serious job.
Excuse me, sorry,
I am talking to
there
Ms.
was analysis of four common driveways that was done back in April.
Yes.
That would be a good start.
Thank you. Ms. Lind.
What I'm going to make a suggestion is that we continue this to a date and time certain in March, and then we plan just collectively for the next meeting, which will be February 9th, to have everyone take some thought about what they want to determine between then and March. We can have public members comment, we can obtain all these things and then get a more concrete idea. Because I think we've heard a lot tonight, and I think people maybe need to reflect on what they'd like. Clark distributed some material earlier today that would be happy to distribute to a larger audience, that everyone can be on the same page and have time to look at it. So would you like to proceed that way?
Yes.
Yeah, that's fine.
Okay, so I'm going to recommend, so we our two March meetings are March 16th and March 30th, because we have such a long gap between our last February and March meeting. I'm going to suggest we put this on March 30th. And then at that point, you can determine if you want to continue to a date and time certain after beyond that.
Motion to continue to March 30th.
All right, I also just want to acknowledge that there's a comment in the chat from Virginia Jensen, who says, from my perspective, the planning board is trying to look out for the safety and interest of property owners in town by addressing this issue. So thank you. I don't want that to get lost in the minutes.
Can I just make one point? Regarding the request to study these four common driveways, everything. The change in the common driveway regulations that are real. The significant change here is the number of lots that would be allowed to be serviced by it. It's not the condition of common driveways in the town today. The condition of a common driveway today only becomes an issue if this regulation were to pass and an upgrade were to be required. The real core issue is, do we want common driveways to serve 8 lots? Now, Steve Bjorklund said it was a great thing, but I didn't get to ask him the question because, and I know from the working group, we have the data. There's no other town near us that uses 8. 3 is the median. Some are 2, some are 5. We're 8. We are an outlier in that. And that's the core issue with the common driveway, is how many lots should be served by it, not what the condition of the driveway is. And I just would ask us to
I've
focus
made a
on
motion.
that.
Okay, so
Someone second it?
what we have done is we just heard that there's an item of focusing on the large number of lots in our situation versus others. All right, we have a motion that's been made. Can I get a second?
Second.
Roll call vote, Clark Brewer,
Aye.
Tom Callahan,
Aye.
Paul Grady,
Nope. No.
Eric Potter,
Potter, I and Tom, and Amy, everybody on the board, there is no personal, it's not the personal at all. I'm just trying to play devil's advocate here. So just so you know, Tom, I highly respect everything that's being done. I'm just looking out for the board in general, but
I hear you, Eric. Don't
Amy
worry.
Glassmeyer, aye. Thank you, Carolyn. Thank you, Lauren Lynn. Thank you, planning board members. We'll see you in 2 weeks.
I'm sorry, Madam Chair.
Oh, I can't do that. I can't, I'm sorry.
We actually, so this hearing is continued to March 30th at 6:30 p.m.
Okay.
And then we just have some minutes to approve, and then we'll have to entertain a motion to adjourn.
Right, thanks, sorry.
Make a motion that we approve the minutes. Lauren,
Second.
fill in the dates. Fill in the dates.
Hold on, I just gotta pull them up. I just had them.
Sorry.
Okay, so it's August 11th, 2021, October 20th, 2021, December 1st, 2021, and January 5th, 2022.
Okay.
Wow,
move
we're
that
up to date. That's fabulous. Thank you, Angela.
Move that all 4 sets be approved as written.
Thank you. Clark Brewer, Tom Callahan, Eric Potter, Amy Glassmeyer, aye. There are no committee liaison updates tonight. Planning Director, do you have updates you'd like to convey?
So just quickly, I'll tell you about the next 2 meetings. I know it's getting late, so I'll keep it brief. We have a meeting on February 9th. We'll hear 26 Lambert's Lane, the A&R and the Common Drive again. We're going to have a discussion about some of the goals we've identified that we wanted to pick back up on relative to the village and the harbor. Some liaison updates. It's a light meeting. 2/16, we hear a new large house review at 270 Jerusalem Road. We hear 12 Parking Way, the Oyster Bar come back for their special permit for the entertainment piece. We have 580 Jerusalem Road. It's a scenic roads application that's for a retroactive tree removal in the Chown right of way at 580 Jerusalem Road. And we will also hear from Heritage Lane again. And then just a couple more items quickly before you conclude. Other pending items that we have heard from in the town departments are 55 South Main, as you know, that's been on the horizon for a while. That's the gas station in the village. And then most recently 44 and 84 Border Street, which is the current site of Atlantica and the Lobster Pound buildings. They have approached the board. They've been, the town inquiring about the permitting paths. And what they're doing is due to the complex sort of Chapter 91 modifications and the zoning that would result with a full raise and reconstruction of a new structure. What they're doing is just a major renovation to the buildings, and they plan to keep restaurant use, to maintain the Lobster Pound use, and introduce potentially some new commercial or restaurant use and an inn style of short-term accommodations. So that's what they approached the town with from a concept perspective, and they will be looking to apply for the zoning board and the planning board likely within the coming month. And then
Are they going to come before us in a conversation, Lauren? Is that what you're saying? Is that
they will? Yes, they will be before the board.
Okay,
Yeah,
they're not asking us for anything. They're basically giving us an update for what they're doing.
So they're going to apply for a site plan review.
Okay.
Yeah,
And then they need special
most
permits
of
to the
this-
zoning board.
Right, okay, yeah, okay.
And then finally, just, which as you've heard earlier, the return of 94 Black Horse Lane, we heard from their engineers who are contemplating opportunities to maybe modify their plan to return. So more to come on those 3 items. And that's all I have for you for now. I will wait until our next meeting to give you committee and other sort of planning initiative updates.
Did Grady leave already?
He did, yes. I think he left when
All
when
right.
we closed the
So
last hearing.
can we have a motion to adjourn?
Motion to adjourn.
Second,
Roll call. Clark Brewer,
Aye.
Tom Callahan,
aye.
Eric Potter,
Aye.
Amy Glassmeyer. Good, thank you. Good night, Lauren. Good night, Carolyn, and we'll.
Thanks, everyone. Good night.
Thank you.